set. And they were using this to say that they were exempt from the antitrust laws because they were compelled by a sovereign, that is the Minister of Commerce, to set the relevant prices. I'm not sure of the current status. I think folks who cover antitrust law a little bit more carefully would be more familiar than me.
There's no reason why you wouldn't be able to find out. If you knew the name of the case, you could check the docket and see what happened. The only reason you wouldn't be able to find out the result would be if there were a settlement and the terms of the settlement were confidential, and then you would see that the case was dismissed. But if there was a resolution, it should be a matter of public record.
While we're waiting for another question, Carl, I just wanted to interject on discovery, just with an observation, which is that, I think at least in the IP context, this Federal Circuit in particular, is very conscious of the high expense of discovery. It's been trying to control it. That's what's happening on this side of the ocean. On the Chinese side of the ocean, the civil procedure law has been amended to provide modest discovery, and the patent, trademark, and copyright laws are being amended to provide a little more robust discovery. So we're actually seeing a degree of merger, which is probably a fair and equitable process, reduce the oppressive state of discovery here and provide more access to information over in China.
First here? Yes.
My name is TK Chang. I've been involved in U.S.-China business for many years. In contrast to previous years, when hundreds of Chinese companies, China-related companies, were taken public here, either through reverse mergers or conventional IPOs, last year there were very few Chinese-related companies being taken public. In fact, many Chinese companies are being taken private. Do you think all this litigation is hurting, from a global point of view, the U.S. capital markets? I mean, it's hurting the New York Stock Exchange. It's being taken over. So,
people on this panel don't want to respond. We can also leave that for the next one.
It does seem like a question for the next panel, but to briefly answer it, I don't think anyone would deny that there's a huge decrease in the amount of capital markets activity involving Chinese companies. I think everybody recognizes that, and to what extent is it litigation, and to what extent to other issues? It's probably hard to separate the two completely because they're probably tied to each other to some extent. But certainly, a lot of Chinese companies I'm aware of were very surprised at how the securities litigation process worked in the United States, where it often seemed like you would have a filing as soon as the stock price shifted, regardless of whether or not there was any merit to it. So I've heard that complaint a lot.
In the back there?
Hi, Steve Schuster. I'm an attorney here in New York. My understanding is that even if you get a default, get a judgment here in the United States against a Chinese company, you're not going to be able to get it enforced civilly in China. And that the better approach is to try to get the Chinese company to contractually agree to arbitration.